Hello and welcome to episode 5 of the Parliament Podcast. I'm your host Andy Segadin, online managing editor of TLR Review Volume 91. There's been a lot of interest recently in media law and the rights of news outlets and reporters, and so we're very excited to have recently sat down with Kaitlin Gurney. Kaitlin's a former journalist and member of TLR Review's editorial board. Today, she represents media companies as an associate at Pepper Hamilton here in Philadelphia. Our conversation spanned over public information requirements, libel laws, and the influence of social media. We hope that you find it informative and enjoy.
We are very excited to welcome Kaitlin Gurney to the podcast today. Kaitlin is an associate at Pepper Hamilton here in Philadelphia. She earned her undergraduate degree in journalism from the University of North Carolina and worked for several years as a news reporter for the Raleigh News and Observer, Charlotte Observer, and Philadelphia Inquirer. She came here to Temple for law school and served as a note comment editor on TLR Review Volume 82. Now she represents media companies and newspapers in a variety of matters. She's here today to talk to us about media law and First Amendment law in what is a very interesting time in the news industry. So without further ado, welcome, Kaitlin, and thank you. We're very happy to have you.
Thank you, Andy. I'm glad to be here.
Excellent. Well, before we get into some of the substantive things that I'd like to talk about today, I do want to your career path from journalism to law. You'll either be our fifth or sixth guest, depending on when we post this, and our second former journalist already. I know that we have a few professors here that also worked in journalism. I started off as a small-town reporter, so I'm curious what led you to a career in law and how that transition has been for you.
Well, I think journalism and law is kind of a natural pairing, and I think I'm a better lawyer having been a journalist, no matter whether I'm practicing media law or not. I think there's a lot of real natural similarities, and not the least of which is being able to type really fast. Made my notes valuable in law school. But it has been a hard decade or two for journalism, and I am married to the industry. And it came a time when I needed to diversify my little family corporation, and I obviously didn't get that far, given that my old employer is still one of my clients here in Philadelphia. But I got a little further, and so it's been a wonderful transition for me, just in that, you know, I love to learn, and whether you're writing a story or taking on a new case, there's always a lot of new adventures ahead, and that's very much been the case.
And you just mentioned it's been an interesting decade or 2 decades in a number of ways for the news industry. You were a reporter just over a decade ago, but as you mentioned, a lot has changed since then. And I was speaking with another guest a few weeks ago, and she made the point that there aren't really any Walter Cronkites anymore. And I think what she was alluding to was that people seem to gravitate more and more to cable news channels, to websites that have a political slant that maybe that suits their ideology best. Has that transition struck you now? I mean, obviously you said you still have a soft spot for journalism, but now you're more of a consumer. And I guess how, if at all, do you see that kind of influencing or getting into media law?
Well, it absolutely influences media law and the various defenses. You know, I am a consumer of media, but I'm also at root a defense attorney. And so I'm always thinking about how I could defend a reporter in regardless of which medium. And the change, there's been some changes that have been good for defensive reporters. There's been some that are a little more difficult. But one of the things that has this slant that you see is actually creates a whole new defense. So you know, think back to First Amendment Media Law 101. If you are expressing your opinion, then that is not a statement that can be proven true or false. And you have a whole nother weapon in your arsenal of media defenses, and that absolutely can be used. And frankly, in the whole world of talk about things that didn't exist when I was a reporter, Twitter, there's this whole world of defamation law called Twitter libel. And one of the things that is most effective is arguing that any statement someone puts out there on Twitter is going to be tinged with their opinion, and so it ends up actually being fairly helpful and effective. It's not, it's not absolutely foolproof, so please don't go out there defaming people on Twitter. We can only take it so far. But I think that slant that you see, and it's absolutely true, does make it so people expect there to be a point of view now in what they read, and that opinion defense goes over a little bit better with the court. You still have that same basic check you need to be asking yourself, is this a false statement of fact? Even in an opinionated statement. But I think that's one way that advances have changed for the better in terms of defending a speaker, which is always what I'm thinking about.
And staying on that same topic real quick, I guess, do you see your clients or just other media outlets in general kind of feeling the need either legally or just to maintain eyeballs, kind of going more that route? Obviously, we all grew up with a local paper or the local news anchor that was always seen kind of, straight down the aisle. I guess, do you see, a pressure to slant more one way or the other among your clients or among people that you see?
Well, absolutely. There's been a fundamental change. When I was a reporter, we were still in the age where you would get both sides of the opinion, both sides of a debate, and if someone was terribly off base, you wouldn't call them on it. But now you see the New York Times on its front page call the president, I don't know if they've come out and used the liar word, but I actually think they have. There is an absolute, it feels like that has changed. There is now, if something is absolutely wrong, it is being called on by the press. And that, you really see that change happening within just the past couple years. And because I think there was some sort of thoughtful criticism of the media industry by itself, and it realized that they were doing a disservice to the country when they knew something was false, but they weren't actually saying that. Now, is it dangerous a little bit as a media lawyer? Yes, it actually is. But remember, again, getting back to those defenses in your arsenal as a reporter or frankly as any kind of speaker, when it's a true statement, that's not defamation. So you're protected.
Now, we're very lucky to have you right now because you're fresh off of just a few weeks ago. You made a presentation to the Pennsylvania Bar Association on media law and First Amendment. I do want to go through some of the topics that you talked about there. One was prior restraint, and common law students would be very happy to see that you included cases like Neer versus Minnesota, New York Times versus United States. In the presentation, some of the examples you gave were hypotheticals like, what if Michael Wolff not allowed to publish his book on President Trump? Or what if 60 Minutes was unable to air its interview with Stormy Daniels? Do you see precedent which generally disfavors prior restraint ever changing?
I really don't. I think that principle that prior restraints are bad and that they're really the opposite of what the First Amendment is about. No matter who's in office or who's on the Supreme Court, that principle is just so enshrined in what it means to be an American that I don't see that changing. What you do see, though, after that speech happens is where the change occurs. So there you see you see someone trying to contract, in the case of, say, Stormy Daniels and a non-disclosure agreement, you see someone trying to contract away First Amendment rights. Now, she could easily end up being vulnerable for her speech after it occurs and having to pay for that. But she's still going to get to speak, and because that's just so fundamental to our country's DNA. And so yeah, just because there's no prior restraints and there's unlikely to be any doesn't mean that there won't be a big old defamation lawsuit, invasion of privacy lawsuits, and non-disclosure and contract arbitration. So that basic principle is any punishment for your speech needs to come after the words are spoken. Is pretty built in.
And staying on that topic of, I guess, publishing unflattering or undesirable news, understanding that, as you mentioned, if it's true, it's usually not an issue. President Trump has, I guess, since back, I was reading articles back in like 2015, 2016, has discussed, I guess, refining or visiting or doing something with libel laws, primarily due to his displeasure at the media and perceived lies about himself. From my understanding, everything I've read, libel laws are really defined in state law. But so my question, I guess, is there anything that can be done? Is there a federal statute or executive order possible? And is this something that your clients are concerned about or even thinking about at this point?
Absolutely. I think, President Trump has ushered in an era of journalism, of really making statements. I mean, he's been flat out that journalists are the enemy of the people, and that's come across a lot of different ways. However, when he says he wants to open up the libel laws, you bring up a really good point. These are state laws, and the president can't change them. In fact, in many cases, there's not even a law; it's common law. So you're dealing with
common law, yeah.
You're dealing with decades of precedent in various different states, and it really changes. I mean, I can tell you that litigating defamation cases in New York is nothing like litigating a defamation case in Pennsylvania. You would much rather do that in New York or better yet in California. Pennsylvania is not a friendly place to be sued for defamation. I'm sorry to tell you. So no, there's really very little Trump can do. And then also, again, there's the First Amendment. That federal component of any defamation case is actually a defense. So that's your best defense. And Trump has nothing to do with that either. That's just plain old the First Amendment and whether those laws run against the First Amendment guarantees. So I would say defamation law, there's always trends and changes, and I think what you're seeing is you are seeing a lot more activity in defamation cases, whether it's Gawker and invasion of privacy is the new cause of actions. You see this turn to non-disclosure agreements with Trump. So there are trends, and he may embolden libel plaintiffs to go ahead and sue the media, but I don't think he can really actually change the laws themselves. Now, I think, unfortunately, anyone who's been a defendant in a lawsuit would say, I mean, defamation lawsuits tend to be very personal and messy, and often just getting sued can be we do our best in the defense bar, but often just getting sued can be fairly punishing in and of itself.
And staying on the topic, you mentioned, I guess, trends in defamation. I know, again, so far these have been largely true, but another topic that came up in your presentation was defamation in the Me Too movement, in the Me Too era, and liabilities associated with making claims in the press. Obviously, a lot of prominent figures have been exposed in the media with allegations of sexual assault in recent months and years. Ronan Farrow has produced numerous bombshell, very widely read stories in the New Yorker. But in your presentation, you note that such allegations do not come without risk. and that to a certain degree, the underlying truth of those claims becomes very important. In other words, I think you make the example that a publication couldn't hide behind the fact that an actress credibly claimed that Harvey Weinstein assaulted her and totally avoid liability if that ends up being false. How are you seeing, I guess, publications handle what is, for I guess, lack of a better term, popular news topics right now? Obviously, defamation in the Me Too era being one, but there are a lot of, I guess, more active journalism kind of following these kinds of stories.
Well, I think the Me Too era is very important for journalism. That victims are feeling emboldened and speaking out, and their stories are being carried by the media, and that's a terrific development. As a defense lawyer, I'm always in favor of more speech. But in terms of having to defend the publications that are running these stories, the Me Too era is challenging. There's no question about it, because we are dealing with really fraught, really personal allegations, and it runs up. These are allegations. Remember, we were just talking about false statements of fact. Mm-hmm. Well, when someone says I was assaulted, and he did it, you're dealing with a statement of fact. So this is a dangerous accusation to be published, and mm-hmm. reporters have. We were talking also about fact checking, and there is. Often, reporters will just simply report the news, but when you are reporting for the first time an allegation, you'll see that reporters are trying to verify to the extent they can, searching for the truth, because they find that's their responsibility, both to the public, but also if they want to allow themselves some protection. So remember that the accusers, so all the way back to New York Times versus Sullivan, that the category of the person who's being accused is really important here in terms of whether the press is able to defend themselves. So if we're talking about just your average Temple Law student, that's probably a private figure. But if we are talking about a future justice or now a justice of the Supreme Court, that's a public official. Sure. When we're talking about Harvey Weinstein, we're talking about a public figure. So it's a little bit easier to report, or it's a lot easier to report on someone who qualifies as one of these public figures, just because you do your due diligence, and as long as you don't know it to be false, and there's no suspicion or any sort of, you do your checks and they all come out true, they all come out that this is correct, you can feel comfort that you've done what is required. When you're talking about just someone who, this isn't big news, but maybe circumstances make it newsworthy of some sort, you need to be careful, because then you're just dealing with negligence, plain old tort negligence, and that can be a pretty scary threshold to be defending against. So no, Me Too era important, but I think you see reporters handle it really carefully, and that's great, as they should. But you bring up Ronan Farrow, and one of the things that I thought was so interesting is that story broke. He broke the story of the second Justice Kavanaugh accuser late on a Sunday night, and it was really interesting as someone who consumes a lot of media to watch how that broke. So he broke it for the New Yorker, and normally no one in the press ever wants to give someone else credit, right? You want to be first, and you want to break that news. But the only time you don't want to break the news is if you're a little unsure about it, if you're a little nervous about it. And there you saw the New York Times, the Washington Post, they really held back for a while because they could not independently verify. And then once once they decided they needed to publish that, they went ahead and they put it in the New Yorker's. They said they made the New Yorker the news. They said the New Yorker is publishing this evening this.
Yeah.
The New York Times could not independently verify that. So that might seem subtle, but it has real meaning in media law in terms of being able how you would defend that. So there is a defense if you're relying on a reliable news outlet. And that's where you see them reaching for. But then they couldn't claim to be first, which, for a lot of these outlets is sad for them. So no, Me Too is interesting and really, really fraught and not over by a long shot.
And do you just, I guess, keep on that thought? You mentioned, I guess, the work that goes into verifying and doing your homework. I guess, from your experience, either as a reporter or maybe just, in advising people now, I guess, is there a lot of news out there that kind of, lands on the cutting room floor because it's close but just not close enough? I guess, where's that line?
Well, I think often news is reported simply because it's news, right? It's the president says something that's newsworthy for just the fact it was said, if nothing else. There's a car crash, there's then you get to feature stories and you need a hook of some sort, or sure, are there cases where things are found not to be worth the risk? Absolutely, if that happens. But I think when something is truly news and editors really think something should be published, I can tell you that as a defense attorney, I don't ever think my job is to say, hey folks, I don't think that's safe to publish. I consider it my job to figure out a way to get that news to get out and to caution about the risk and what we could do to limit the risk. But basically, no, I consider it my job to help people figure out how to speak and how to do that as best they can.
Very cool. And I guess in your presentation to the Bar Association, you also mentioned reporting, and we're kind of getting to this topic now, legally obtained information. And it reminded me of a Houston Chronicle op-ed that I read in preparation for our call. In the op-ed, Frank Lamont, a professor at the University of Florida, was discussing a CNN journalist's exclusion from a European trade announcement back in July. And like you, he talked about the right to report information obtained, but noted that things get fuzzier in terms of the right to obtain that information in the first place. He discussed the lack of constitutional right, for instance, to cover a criminal trial. And he also noted that if the government is cutting off your access for a retaliatory reason, that could spark a First Amendment issue. I guess with reporters' rights, as you mentioned, kind of evolving or changing or in need of better clarification, where do you believe that the line is? And I guess what you think is reasonable personally?
Sure. Well, let me actually make one just note. There is a right to cover a criminal trial, and that right can be limited in certain circumstances. But that is actually one place where you do have a right. In other situations, it is a lot less clear, and there is no. Reporters are not. They may like to think they are, but frankly, they're not special in the eyes of the law here. There is a First Amendment right for anyone to go out and speak and to report information. But, whether you're a reporter for the New York Times or just someone with a very popular Facebook account, it's a pretty democratic principle in terms of you get to speak, period. But in terms of where that information and legal information, I think you do see some things that are really changing, and it's a real sort of unsettled area of the law. There's some court cases, as usual, that give us some guidelines, but some of the finer print has not been decided. So one of the most interesting cases on here, it actually took place in Pennsylvania, is a case called Bartnicki. It's a Supreme Court case. And there, it was in the midst of a hotly debated union contract negotiations in Pennsylvania. And someone taped a secret union conversation and mailed it into, and Pennsylvania is a two-party consent state.
Two-party consent, yeah.
Yeah, you need both people to say it's fine to tape. Otherwise, so everyone just keep that in mind. Don't just whip out your iPhone and start taping things when someone could argue that they have an expectation of privacy. Practice point for today. But so that tape, an illegal tape, was mailed into a radio station and it was played on the air. And the radio station was sued, and that went up to the Supreme Court. And the Supreme Court said, listen, if you were given the fruits of an illegal taping here or illegal information, and you had no involvement in how that came to be, then you may use it. And so that comes up in the case of like WikiLeaks, or the Sony hack. So reporters can take the fruits of that illegal act and publish it, and we all read it. We all, we all have a little bit of that prurient interest in ourselves, where it's really interesting to read people's private emails. But there's no question that an illegal act took place at some point, and whether WikiLeaks was involved in that is questionable. But whether, say, the New York Times, when they report on it, whether that is answered by Bartnicki, and they do have the right to report on that. But then I think where it gets a little gray is anyone who's a consumer of news may have noticed in the past couple years, there's a lot of these sort of curious drop boxes that have showed up on a lot of news agencies' websites. ProPublica has one, New York Times has it, Washington Post has it. It says, be a source. Give me your stuff. Be a leaker. And if there's an invitation there to share information and to share, frankly, information that may be illegal or classified. And that case we have not litigated yet, which is a matter of where does that line fall? Where do you have a reporter who has some degree of culpability for getting involved in encouraging the illegal act?
And
so that's where I think you could find some real liability happen, and we haven't seen that case yet, but that's not to say that it won't happen.
So just so I understand, I guess the difference there would be in a Bartnicki situation, you basically, the news is out there and you're just reporting it, and you didn't have any, but I guess the other idea would be you're soliciting potentially illegal behavior.
Absolutely. And yes, one the news lands in your lap. The other one, you could be seen in some cases as a conspirator. And the classic case for that, it's a little outside of Bartnicki, but the same principle applies. Is there's this thing called the Espionage Act, and it's never been used against a reporter, but it has been used against leakers. And it is a World War I era, the 1917 law used to punish leakers of classified information. And it is not limited to the leakers. You can also punish the publisher. And a lot of folks in the media bar are just waiting to see if this law ever gets used against a reporter, against the publisher. And the way that would be used would be there's a conspiracy element there. And it would look at the relationship between the leaker and the reporter and whether there was a conspiracy to publish this, what kind of encouragement took place. And that's where you could see some punishment for speech, which we started off by saying is really unusual in our country, and it still is. But that's not to say it couldn't happen.
And keeping on the topic of, I guess, accessing information, I remember my time as a small-town reporter, we always had a lot of fun filing those public information requests. And I know that's a topic that's been debated recently. I was reading a Seattle Times editorial recently about efforts to exempt legislators from the state's transparency bill. I understand that there was some similar public criticism about an existing law in Massachusetts. Do you expect these exemption laws to eventually die out, or the exemptions in these laws to eventually die out, rather? And if so, I guess what sort of information is out there that the public would potentially gain through the removal of these legislator exemptions?
Well, I got to say that unfortunately in Pennsylvania and in a lot of states, you find the very legislature that enacts these access laws finds it behooves itself to exempt themselves. And so that absolutely, Pennsylvania is no better. You can't get information about the legislature except in very certain circumstances. You can get it about the courts, you can get it about the governor, but not about the legislature because they signed the law. And so unfortunately I consider that sort of an evil of dealing with a creature of state law. And FOIA, you find that it's the backlog, but in state law there's a lot of exemptions. And unfortunately, when you try and get the news out to the public about the exemptions, that's not exactly a sexy story. It doesn't get a lot of eyeballs. But there's no question that access to information is really important, and especially government information. And one way that you see this happening nationally right now is there's been all these incentives that have been offered to where the Amazon headquarters 2 is going to be. And so all these cities across the country are competing. And then there's been all these open records lawsuits filed, and it's been really interesting to watch information that I believe Amazon has required to be kept under, lock and key, and watch it conflict with all these different public records laws. And you can see that really none of the information has gotten out. In fact, Pennsylvania is the most progressive here. It's rare that I can trumpet Pennsylvania as progressive, but we just had a judge in Pittsburgh say that under the Pennsylvania right to know law, Pittsburgh needs to release the incentive package that they offered for Amazon's headquarters 2. Now, that would have ramifications because Pennsylvania or Philly also obviously bid and got pretty far. It may not be the winner, it appears, but so that's promptly appealed. And it's interesting to watch, just all across the country. There's very few states that really have perfect open records laws, but Pennsylvania is certainly not among them.
And I feel bad because you just complimented the Pennsylvania law to a certain extent, and here I'm going to ask you: Pennsylvania received an F in the Center of Public Integrity's 2015 ranking of public record laws. That sounds really bad, but obviously the center was looking for, I guess, a more expansive view of these laws, because I think only Alaska, California, and Connecticut scored above a D+. So I guess, obviously this was a few years ago, but has Pennsylvania law evolved at all in recent years? And I know you're mentioning the legislator exemption, for instance. Are there areas that you have a particular concern, or your clients have a particular concern, and would like to maybe see an improvement or two?
Well, the Pennsylvania, there's been movements in Pennsylvania. The local journalism association here has worked very hard to improve Pennsylvania's right to know law. It actually is a pretty new law, and for the most part, it's better than its predecessor. Again, I don't know if that's saying much, but the Pennsylvania right to know law only has existed since about 2008, and it is not a perfect law. It is no California, Florida. It actually takes it has a very good law. New York. These are some of the best places to get information. But I think my example about Amazon just then shows you that, like, no, these are all creatures of state law. They're all going to have exemptions, and none of them are going to be perfect. And what you can do is litigate and hope that public access argument will pique the interest of a judge. It did in Pittsburgh in Pennsylvania's case. That I should note was very promptly appealed, and so that case is not over. But these laws are evolving, and none of them will be just right. But Pennsylvania is better than it was, and the best we can do is keep litigating and hope that access will win out. And unfortunately, the thing about litigating is it's expensive, and so that is one of the real vulnerabilities of the Pennsylvania law from my perspective, is you can win a great victory like these folks in Pittsburgh just did, and you end up with more legal bills because it was appealed. So that's the real downside.
And I know that you mentioned several times in our conversation you obviously have a soft spot for newspapers, but as we wind down here a little bit, I would like to talk about social media, where I guess despite newspapers, you both of us having a soft spot for newspapers, an increasing number of people are receiving and sharing their news on Twitter and other platforms. President Trump is a common example, but an increasing number of government officials use platforms like Twitter to interact with constituents and share opinions and their own news. Earlier this year, the Southern District of New York held that President Trump's Twitter account is a public forum, and that a de minimis First Amendment injury was caused when a collection of users were blocked by him. Looking beyond just President Trump, what do you foresee being the benefits or potential consequences of public officials' social media profiles being considered public forums?
Well, it's a very interesting and sort of arcane area of the law, but you're right that we've seen a lot of it. And one of the interesting things, we were just talking about access, is that means you can't block someone, because that would be state action. Normally, Twitter can block who they want. They are not state actors, but President Trump is, and that's what you've seen a couple courts find, is that because it's a public forum, because he's choosing to interact with the public that way, he can't block people from interacting with him on Twitter. He's still trying, I might add. I think a lot of folks have been blocked, but that really brings in an interesting intersection of sort of the private industry like social media, and then state action. And so it basically, these public officials are co-opting a private platform for government use. And there's all kinds of interesting ramifications if you go down that hidey hole. And I don't think this has been played out at all. It also has interesting ramifications in terms of what sort of preservation obligation do you have. So social media, as anyone can, who's been on their nose, is usually rather ephemeral. It can be taken down, deleted, but when you have the president choosing to break news, to speak on Twitter, well, that's subject to FOIA. It's subject to all kinds of preservation obligations for the presidential archives and the like. So no, there's a lot of interesting effects of this, and I don't think we've seen it play out at all.
And staying on that same topic, I guess, do you see this, trickling down? Obviously, the president, that's obviously the most prominent position in the country. But if the president's Twitter is a public forum, is the governor's a public forum? Is a small town mayor's a public forum? I guess, obviously, as you mentioned, there's a lot to be seen here. I guess, do you see those kinds of arguments coming down the pike?
I think you do see them coming. I don't think they're going to be there's nothing as sexy about a small town mayor's Twitter account. I mean,
Sure.
in most cases.
Yeah.
So I don't know that you will see the public claim for to be as interested in it. But no, I don't think this is done, and that precedent would absolutely, state action is state action. So it would it should definitely trickle down.
And continuing on how social media is used and informing how we communicate, the social media platform Gab has been in the news recently because the Pittsburgh synagogue shooter was a frequent user, evidently. There's been plenty of reports of inflammatory and racist messaging being shared on very many platforms. And I've read that white supremacy has been, gravitating toward platforms like Gab. I've also read that this sort of speech does not fall under the auspices of the First Amendment, and companies such as Facebook and Twitter are able to avoid liability through federal laws such as the Communications Decency Act. Because how do you see this playing out where, again, the way information was shared, when you were in law school or even as a reporter, is not necessarily how information is being shared today?
Well, I think fundamentally, when you are a pro First Amendment person, you're in favor of speech, and not all speech is pretty or nice. And certainly in the case of the kind of messages you see on this platform Gab, I mean, that's a whole social media platform that is making the calculated decision to trade in such horrible things, and that's that's an ethical dilemma for them, but it is not actually a First Amendment dilemma. I mean, speech is speech, and there is protection for it, except under some extraordinarily rare circumstances where that speech has been found to be a true threat, when there's an actual incentive to act, and in a threatening way. But no, that ugly underbelly of speech, whether it's saying a hateful thing on Gab or the Nazis' right to march on the public square, that is protected by the First Amendment, just the same. And you've actually seen the ACLU, which has always been one of the defenders of the Nazis marching on the public square, and the right to assemble. They have recently stepped back and said they're not defending what we've always thought of as hate speech. And that's, as someone who is a defender of speech, period, that's a little disappointing, because that's the principle. If we start policing speech based on the message, well, that's a big old slippery slope that we've fought long and hard in our country to avoid. But that does not mean that there is not an ethical reason to avoid Gab, or that I hope there's not a reason. I hope no advertiser. I hope Gab can't make a cent. So there's many reasons to avoid, to hope that these that an outlet as hateful as this is not succeeding. But from a First Amendment perspective, I'm afraid they're pretty free and clear.
And I guess to your point, there's obviously not like a First Amendment issue, but there is, I guess, a desire or maybe a moral compelling to cut off some of these voices. I think most notably back in the late summer, Facebook and YouTube removed Alex Jones's InfoWars, and there have been some commentators who have accused media companies of bias, particularly against conservative viewpoints in terms of, what are they taking down? And I know even Attorney General Jeff Sessions convened state attorneys general back in September to discuss whether these actions violate antitrust laws. Do these arguments hold water about the antitrust laws? And as absent government action, do you anticipate more media companies? To your point, this is not something that's necessarily going to touch on a First Amendment issue, but I guess distancing themselves from the kinds of voices that are appearing on their platforms.
Well, I think one of the key points here is we were talking about public forums and state action and the like. And when you're dealing with YouTube and Facebook, that's a private company, so they get to act and make these decisions how they would like. But then to your point about antitrust violations, well, I mean, in this day and age, you talk about how things have changed, and one of those is there is more and more media. So it may be in some of the classic antitrust cases do come, and for not being an antitrust lawyer here, I should note, but do come from a media or sort of a cable communications world and background. That is, I don't think anyone, because in this day and age of media coming at you everywhere and anyone being able to be their own publisher, this is not a situation where I would say that media companies are all that vulnerable to an antitrust argument, because there's just so much speech. And if Alex Jones can't get on one forum, well, he can try another, and has, and successfully, I might add. So no, we have a lot of different speech options these days, and so while I might be worried about other folks in antitrust lawsuits, for the most part, I'd say the media is in pretty good stead.
And before we go, I guess we have spent a lot of time discussing various changes, various challenges, various questions in the news media. Certainly some members of the public distrust what they read, what they see on the screen. I'm curious what you're hearing from clients, to the extent that you can share. I guess, is there a primary concern or two? We're talking about how things are evolving, both in perception and both in how news is gathered, how news is shared. I guess, are there things that you're hearing more than others? Or are the companies that you're representing kind of just chugging along, business as usual?
Well, I don't think any media company in 2018 is necessarily, chugging along. I think all media companies feel under assault in a lot of different ways. I mean, it's come really hard to make any money. It's their reporters end up being vilified when they show up to cover news events. You have the president saying, these are enemy of the people. It's hard. It is difficult to be a reporter in 2018. The First Amendment is one of the few things they've got. So I think it is really demoralizing and to be a reporter. It also, though, I think whenever you have these sort of dark periods, you also, there's some real high points. There's some great journalism that's going on, and that some great investigations that have taken place and that have been broken. And you also see a real democratization in terms of that people can break their own news with their own various, whether it's on social media or publishing elsewhere. So there's some light, but I would say that most reporters are feeling pressure in this day and age, both economic pressure, which is in some ways the very worst, and then political pressure as well.
And finally, I'd like to end our discussion the way we've ended our first few episodes here, with a kind of catch-all. I know that when we were emailing back and forth trying to set this interview up, you know that fake news, I think I mentioned something about fake news, and that isn't necessarily what's driving debates in media law, but it is something, and I guess what is driving media law is some of the things we talked about today, but fake news is still in the lexicon. It's something people just say kind of as a joke, or sometimes very seriously now, and discussions about the media's role in our society are very much part of the public debate. For those of us who might be out there discussing this topic with friends or family, or maybe the person at the stool next to us at the local watering hole, what do you, from your vantage point, either hope that we're talking about or think that we should be talking about when we're talking about media law and the role of the media?
Well, yes, fake news, I would say, isn't really driving a lot of debates on defamation law or that sort of thing, but it is absolutely driving a lot of public discourse. You're right, and we were just talking about reporters' morale, and it is. It's hard to to hear that day in, day out, oh, you're just fake news, as people become more stratified and the like. And one thing that I get asked a lot, I'm like, well, how can I be supportive, or how can I get more politically involved, or how can I? And one thing I say is, listen, if you're worried about fake news, maybe you should go to what you know to be a reliable source. Maybe you should actually support journalism and that might take paying for your news, which, by the way, we all used to pay for our newspapers, and it's whether that's online or to buying a piece of paper. The best weapon against fake news is not sharing something that is questionable that comes across your Facebook feed, but returning to these names in media, and there are more and more of them, and that's wonderful. But where you have working reporters who are trying not to peddle fake news, but to actually bring you news that is real, different, competing points of view, and yes, to support them, whether that's paying for your public radio, NPR, subscribing to an online reliable outlet, a recognizable name, sitting through that commercial on network TV, rather than that's one of your best weapons against fake news, I would say. And is that legal? No. But one of the biggest challenges that the news media has right now is not legal at all, and is purely economic, and whether it'll be able to survive in this new era where things are changing so much.
Excellent. Well, Kaitlin, thanks. It's always great to have a former TLR alumni with us, and this was excellent. Thank you so much for joining us. I appreciate it.
You're most welcome. It was my pleasure.